Turning to planning, can you talk more about some of the other issues that might arise for an estate planner with some of the changes in WESA that affect planning?
Right. So there's a whole part in WESA that deals specifically with the drafting of wills, which I'm going to turn to now. It's part 4 of the WESA. And overall, the making of a will under WESA is not going to be much different to what it was and is under the Wills Act. Essentially, they must be written and signed at their end in front of 2 witnesses, and everybody must sign in the presence of each other, just as they must under the Wills Act. What's going to change is who can make a will and a couple of the details about what invalidates a will or not. So I'm going to review some of the changes that are addressed in WESA, but not all of them. And again, I would commend you to part 4 of the WESA for dealing with drafting of wills specifically. So first of all, the age at which you can make a will is now changing. We can make wills now at the age of 16, although witnesses still must be 19 in order to be valid witnesses. When you witness a will, if you are a beneficiary or a spouse of a beneficiary, you still invalidate your gift. And remember that a spouse, for this purpose, is the broader definition of spouse, including what we call common law spouses, as Helen's talked about. And the relevant date for whether you are or are not a spouse in order to invalidate a gift under a will is the date the will is made. So if your will is witnessed by someone who is not yet the spouse of a beneficiary at the time the will is made, 10 years later they become the spouse of one of the beneficiaries, that gift is not invalidated by virtue of the prior witnessing. One of the other interesting things to note about the witnessing provisions with respect to beneficiaries and spouses is that the court has a power to save a gift to a beneficiary where the court is satisfied that the will maker intended to make the gift even though it was witnessed by a beneficiary. This is consistent with a trend of sort of substantive validity and the idea that the court will uphold wills if they have technical problems with them, and Helen's going to address that a little bit later. For the purposes of the witnessing, extrinsic evidence is admissible to determine what the intention of the will maker was.